Yes, I think
Go for
I've got perhaps 20 minutes left just to give the court an indication.
Thank you.
So, just before lunch, my lord put to me the points set out in MH paragraph 43, and my response had been, well,
Paragraph 45, isn't it?
I think it's well, 43 is the analysis that leads to it, which refers to the other cases that illustrate a similar principle, which is that if the claimant gets the relief he sought for a reason which is unrelated to the claim, for example, a certificate is withdrawn for reasons which have nothing to do with underlying merits of the claim, but because the Secretary of State allowed the relevant time to expire, the claimant is not for that reason entitled to his costs when the claim settles. And that is based on ZN, Afghanistan and Araso. And in my respectful submission, when I said that there's a compression of the case law in this judgment, that is right. What's missing from that sentence is the word normally, because it comes from ZN Afghanistan and it comes from paragraph 67 of ZN Afghanistan, which demonstrates, at page 170 of the authorities bundle, which demonstrates the court's response to Mr. Nafla's submission that there doesn't need to be any link between the merits of the claim and the act.
But we're in a broad discretionary area. I think that's entirely well established and well settled.
Exactly.
And I don't think anyone is suggesting that there's anything hard and fast here.
No.
But it's just the appropriate approach to, as a matter of principle.
Sure.
And I think what is important here is that if 43 sets out the general principle, 45 specifically applies it to a situation where the certificate was withdrawn because, as a result of leaving the EU, the United Kingdom is no longer a party to the Dublin III regulation. There is no causal connection between the proceedings and the withdrawal of the certificate. And that, as I understand it, is entirely on all fours with our situation.
Except that it isn't, in my submission, because that is a case which was an appeal from an adverse judgment. And
why does that matter? Because the permission to appeal had been given.
Yes, but
it was entirely
It matters because, as I was trying to set out earlier on, was that these cases are fact sensitive and nuanced. And of course, the fact that one judge could take, that one judge can take the view that actually, well, I'm going to look at this litigation and overall I take the view that you haven't succeeded. But another judge could take the opposite view and both judges still be legally unimpeachable from an appeal perspective. And these cases are nuanced. And so in my submission, that makes it fundamentally different.
The fundamental material, that you say it's a fundamental material distinction, do you?
Correct, I do. Thank you.
That the decision has been adverse to the claimant at first instance,
yes,
even though it was entirely arguable on appeal.
Yes. And the fact that, and that approach in my submission is entirely consistent with the way the court has dealt with it in these other cases that we went to earlier on this morning. Allied to that is the circumstances in this case. Now, when the matter came before Lord Justice Dingemans in April 2020, Your Lordship asked Mellon and Friend, well, what did the government think was going to happen at this point? And part of her answer, and I may have misunderstood, was, well, they had to proceed because the claimant was raising these points and they needed to be determined. And of course, certificates are mandatory in this field. And in my submission, none of that is right. Certificates, third country certificates under Dublin III, are not mandatory. They are discretionary. So the Secretary of State retained the discretion in April 2000, and indeed before, to withdraw a certificate. The position is that that the Secretary of State was required to consider the third country a safe country. That's where the requirement was, subject to certain exceptions that are irrelevant, but was not obliged to maintain a certificate. That is a discretionary decision, and insofar as any authority is needed for that, I've got one. My learned junior dug it out very efficiently, and it's Secretary of State against FTH 2020 EWCA Civ 494, and it was paragraph 3 of the Master of the Rolls' decision.
What do you say the Secretary of State should have done here? She should have exercised her discretion to quash the certificate at this point when you're in front of Dingemans.
Yes.
At which point, I think, reading back through, Secretary of State is still maintaining and has made no concessions at all on age. Wasn't that absolutely part and parcel of all of this?
That, of course, she's made no concessions on age, but, of course, everybody knew, because by then the relevant EU withdrawal act, the agreement had been signed back in 2019, I think. I looked up the chronology at some point of all of this just to remind myself. It seems recent and far away at the same time in the funny sort of way. And so in April 2020, it's a totally justifiable question to say to myself, well, what did the Secretary of State think was going to happen? We're in the middle of a pandemic. The Brexit date is looming. It's only 8 months from that date. And she could have, at that point, said, right, well, without any concessions, I accept that I'm not going to be able to remove him. Then we wouldn't have had all this further hearings that were then required. And of course, the claimant couldn't do anything, because if the claimant withdrew their JR, they could be removed.
Yeah, but the point won't be lost on you that the Secretary of State doesn't really have a free hand to exercise discretion in these sorts of cases, because if she did that in your case, she would have had to have looked across the whole piece and thought, what other cases do I have in my pipeline that I'm not likely to get to by the end of December of this year? And there would have to be a sort of policy position there.
I don't accept that, actually, because the general position of the Secretary of State is that they look at cases on an individual basis, and there was certainly an awful lot of individual circumstances in this case that cannot possibly be commonplace. Not least the fact that it took, the Secretary of State a considerable amount of time to agree to concede the appeal. And
where do you pitch this? Is it just it's something the Secretary of State could have done or should have done? Was unreasonable not to?
It's part of the conduct
right.
that is relevant to where we say, if this court is assessing success afresh, if you're not with me on my primary submission, which is that actually the approach of the judge below was proper within the scope and the facts of this case, then it's my respondent's notice point.
Can you remind me, when the direction was made for issue 2 to be heard first as a preliminary?
Yes. It's in...
I'm raised this and we haven't actually got it in the bundle.
Oh. I'm getting a whisper behind me. Page 42 of the supplementary bundle is what...
Excellent. I thought. Thank you.
I see.
And you'll see that it reflects the statement of reasons endorsed by the court at paragraph 8 on page 38.
And it may not matter, was this off the court's own motion?
Which bit?
The directions.
I don't know.
Doesn't it looks as if...
Well, I'm told. I hear stage whispers behind me. I'm told it was, but I mean,
Dinkerman's order
exactly
of the April says the claims to be listed for hearing by the Upper Tribunal, which shall issue directions. So the nudge was
yes,
do it on paper. Yeah.
that's
exactly,
on page 35.
and the idea to take the legal point first is also reflected in paragraph 8 of the statement of reasons on page 38.
Sorry, what page was that?
Page 38 of the supplementary bundle, Melody.
Got it. I've got two versions of the statement of reasons, and one doesn't run to paragraph 8.
Oh,
but I have
wow.
found the second version. I've got it. It's all right from there.
Well, that
Yes,
will
you're
be
quite
because
right.
there was an original draft that was then not agreed by the court.
Got it.
Yes, it actually came from here.
Right. So yes. So I think I perhaps sort of overlaid some of my submissions. I wonder if I can just very shortly then just say where that we've got to. In relation to whether the judge below erred in my submission, he didn't, because success is a concept that has some nuance in it, and in the context of the arguments being made to him and his approach, he was entitled to reach the view that there was success. Then, on the alternative point about whether if it was a different sort of case, whether it was a partial success or otherwise, and whether the matter was tolerably clear, I haven't addressed you on that, but I would refer simply to the skeleton argument, which sets out the points in short, and having taken cognizance of the approach of this court, the majority of the approach of this court in MH, about not considering potentially quite complicated issues in these circumstances, I would just rely simply on my skeleton argument in relation to that.
Sorry, this is paras 49 and 50 of your skeleton.
I think that's right. And then the last point is that it is a fallback position, obviously, that if there was an error and the order should be made again, in my submission, for the reasons that we've already gone through, in my submission you should and are able to take into account conduct. I have raised the issue of conduct in the respondent's, properly raised in the respondent's notice, setting out precisely the conduct upon which that is relied. I've developed that in oral submissions as I overlaid my submissions to some extent. In terms of relief, in my submission it would be a nonsense to do nothing and just set aside the decision below, because there would then be an outstanding direction for submissions as to costs. And finally, in summing up, this was an incredibly unusual situation, but standing back, the bottom line is that this case could have been determined earlier and wasn't, and that is actually not the claimant's fault, who will lose actually all his damages, or the vast majority of his damages in clawbacks, if the position ends up being no order as to costs. And by contrast, it was directly partly caused by the Secretary of State in changing her position in July 2018 and then failing to take proactive steps as she is obliged to do, and we all are obliged to under the CPR, but rather we would say chancing her arm to see if permission was granted, and when it was, then negotiating. And what did she think was going to happen when all that only came to head in April 2020? So we've set out all that more eloquently in skeleton argument at paragraphs 51 onwards, and unless there are further questions.
It might have gone against you if we'd got to the age assessment hearing earlier. So we lost about 18 months on the Croker circuit, if you call it that.
Yeah, nearly 2 years actually.
Okay, whatever. But if that hadn't happened, and if you'd had, because it was the age assessment in 2018, wasn't it? That was the
right.
Croker one.
Yeah.
I mean, much of your argument is predicated on you would have won that and you would have had an answer in your favour then. But that's the very point we don't know. You might have lost that, in which case,
I agree.
in fact, it suited you very well to have that delay, because in the end, it's you've had the claim determined here. See what I mean?
Well, I mean, I completely accept, and we've accepted in our skeleton argument, that I can't say that it's tolerably clear who would have won the age assessment had it gone ahead. I'm candid about that. There were witnesses, there were opposing experts. I can't persuade you that we would have won it. But of course, the position of the claimant is that he'd been waiting for years and years and years, 4 years by that stage, 6.5 by the time he got his decision, and had he lost the age assessment, well, we wouldn't be here. I mean, it's all predicated on the assumption that my client is lying, which is also not unfair. You've got to treat that as neutral, because we just don't. Nobody can say what would have happened. And could I just finally say that it's not about penalising the Secretary of State in cost, obviously, even though Malone Friend puts it like that quite a lot, because conduct is relevant to where costs should fall, and egregious behaviour, if I could put it like that, is relevant to the basis of costs rather than...
So I'm keen to pin you down on this. How do you characterise, if you do at all, the Secretary of State's behaviour? Egregious is a strong word, is that what you're saying? I'm not trying to dissuade you, it's an open question. I'd just like to know how you pitch it.
Yes, well, we do say that it was very poor conduct of the litigation.
Okay.
I don't need to become emotive.
No, it's very poor.
But it was poor, and and the appeal was brought...
That's the Croker thing was poor. There are other bits that you say are very poor, or is that really the focus of the argument?
Well, I mean, I think that's really the focus of the argument. I mean, there are other patterns of delay of which criticism could be made, but I'm not going to trouble you with the ins and outs of all of that. I think it would be fruitful.
Can I just clarify one thing? I think you said when looking at the consent order.
Yes.
You said that given that consent order, if the matter had gone ahead, the court would have quashed the decision. And then you said that the age remained relevant for two reasons. One was to damages, and it was open to the Secretary of State to recertify.
Well, it would have been open. So this is a situation in which the rolling nature of judicial review actually benefited the Secretary of State.
Because the certification was never quashed.
It wasn't quashed, no.
So, I'm just what I'm thinking about is Ms. Anderson made the point very forcibly a number of times that what was never established, the cases where you are successful is where you have established success on the basis of the lawfulness of the decision. But what you say, as I understand it, was in this case, well, effectively you did establish, it was accepted, in a consent order, that the decision was effectively unlawful.
That's
Hence,
right.
the unlawful detention.
Yes.
So if the key touchstone here is whether or not the lawfulness of the original decision was effectively determined in your favour, then you say you are successful. you were successful at
A-
that stage.
Absolutely.
And what happened thereafter was the Secretary of State was seeking a second bite of the cherry, and by virtue of the Secretary of State's, some of the Secretary of State's conduct, they never got that second bite because time ran out on them.
Yes.
They say, why should you not get your costs of establishing that a decision was unlawful, and why should the Secretary of State avoid those costs because she was given but never managed to get a second chance?
Yes, my lord.
That's really the way you put it.
That's right.
You did win, and her attempt to recover the position never came to fruition because the clock ran out.
Yes. And just because I anticipate that my learned friend will say, "Oh well, no, what was conceded, the detention was conceded because of Himati," that's simply wrong on the chronology because Himati occurred over a year after that consent order. So just to, in case she makes that, and my learned friend makes that point again, which she has already made in in opening.
Well, you've already addressed that.
Thank you very much.
Thank you. Yes, Ms. Hanson.
Picking up the sort of key point, you were taken to the original claim form and the basis of the claim. The basis of the claim was, I am a minor, so you cannot believe it. As my learned friend has indicated, at paragraph 42 of the respondent's skeleton argument in this court, it is accepted that it cannot be said that the respondent in this court has established that he was a minor. So despite the fact that every local authority that saw him reached a different conclusion to the contemporaneous assessments at the time, the ones that the Secretary of State is obliged to rely on, the Secretary of State can't go against the evidence of the local authorities. All that was established was
Sorry, paragraph 42 of the respondent's skeleton.
argument in this court.
Forgive me.
Wrong paragraph.
Yeah, I think.
No, 49.
Thank you. Just bear with.
Yeah,
Thank
that
you.
is. Thank you for that correction. It's actually the second sentence there. Whilst AI accepts that it's not possible to say that it's clear what the outcome of the age assessment proceedings in the Upper Tribunal would have been, and gives reasons for that, it is possible to say that the timing, the one that arose later, and the sort of second strange timing that arose later because of the time, would have succeeded.
It isn't right, though, is it, to say that the claim was that he was a minor. The claim was that the decision to treat him as an adult was unlawful, which is slightly different, isn't it?
It is slightly different, my lord, but the claim was that he was a minor, because, as my learned friend said, that this is all about, under the Dublin regulation, who is responsible for considering my claims. And prima facie, Finland is responsible for considering the appellant and the respondent in this court's asylum claim. So unless he was a minor, it really matters not whether, and the only reason that the initial decision is now said to be effective, and much is now being made of that, and I'll come on to whether, if this was going to be the point, it should have been made earlier and costs should have been claimed at the time on that basis, is just that the initial local authority decision, on which the Secretary of State had to rely, as it were, there was nothing else, was not Merton compliant
Yes.
in the way. So
That was the basis of the claim was no Merton compliant age assessment was conducted.
yeah. So, but it could all have stopped then, couldn't it? And then the claimant could have got his costs on that basis. That was really the decisive point, as it were. Then the claimant could have pressed to get his costs, and we would all. But you can see costs are being reserved all the way up because everyone accepts that if ultimately it turned out it wasn't a true claim to be a minor, then that was a relevant factor in deciding the costs, because none of these proceedings, there would have been no. The Secretary of State is responding all the time to proceedings that are being brought, and if underneath it all the individual was just doing what many do and say I'm a minor in order not to be detained, if that turned out to be the case, that was relevant to costs, and where the costs of the proceedings, whether they should be recoverable and so on and so forth. And that's why costs are being reserved.
Well, it depends on how you look at it. You can say, well, it's a matter in a sense for the claim must be based upon the assertion that I'm a minor. But in fact, it isn't the nature in this type of public law challenge. You have not lawfully determined that I am not a minor. And the way it worked here was that you accepted at an early stage of these proceedings that you had not lawfully so determined. Hence why the claimant, whether or not he was a minor, gets damages for unlawful detention. And what happens thereafter is that you are effectively, this is the point I just put, this board for, effectively thereafter, through the directions given, are given another chance to have the matter determined, this time by the Upper Tribunal, and effectively that never comes to pass. And the reason it never comes to pass is because time runs out.
Completely reject that analysis, my lord.
I thought you might. You wouldn't be here if you did.
What could have happened, of course, and perhaps in the old days would have happened, is that everyone would have said, right, this particular decision, certification decision, is defective for that reason. The JR stops, as it were, and everyone goes away. And then a new claim form is issued. When a fresh decision is made, relying on then the next age assessment, which also came out, this chap is not a minor, then a new JR is launched at expense, everyone repleads it, and off we go again with another JR. So that perfectly, absolutely could have been the situation. And if that's what the point they want to press now, they should have pressed it then. But everybody accepts that the JR can roll on. Now, if that's the wrong decision to be made, well, I'm afraid, as I say, the time has passed for arguing about that. And I think it is, I personally am not a great fan of the rolling JR. I think it does create complications. But there are also, these are all quite real costs, and it is the court administration having to process it all again, etc., etc., etc. And you can see that in the third country situation, there were probably, it was so complex legally, there were probably quite a few situations where technically something might have been wrong and you'd have to start again every time, if you see what I mean. So a pragmatic approach was being taken to, because you see lots of points were coming up about, say, the safety of Italy, or, there were lots of different things going on. And the proceedings tend, Hamati itself, you can see that was about detention. You can see the arguments, and the Court of Appeal had to deal with really quite a lot of different circumstances and put them all together in one appeal and decide a point to decide then. And so, because there's just so much.
But I'm getting a little bit. We need to bring it back. Is it your submission that really at the heart of this JR, as it was in fact conducted, was the issue of certification, and certification depended on age, because if he was underage, the certificate was wrongly issued, was unlawful. If he was not, if he was an adult, then the starting position was it was a lawful certification.
Yes, and although there was an argument about the age assessment points, etc., etc.
So you can have fancy points. I'm just trying to work out what your case is. You can have points about whether you've approached the age assessment in the right way or the wrong way. And what happened was there was a concession that the evidence on which the Secretary of State relied was inadequate in Merton-compliant terms to age assess. But that just put you collectively into a position of saying, well, we need to do it properly, and that means you go to the Upper Tribunal to do it.
Yeah.
And then you get the sort of croaker problem.
There's an intermediate step in that the local authority do it properly.
Okay.
And then that's challenged again. So in a sense, my lord, perhaps
so you cut out that.
There's a sort of fresh challenge. If my learned friend, because really what's argued against us on conduct, and I appreciate that's a different thing, is you didn't concede. There was no offer of, if we all stop now, we'll draw a line, the costs that go before will say no order as to costs, or something. There was no offer of that. If the Secretary of State had conceded it in any way, the Secretary of State would be facing these cost arguments. So it's not appropriate. And just picking up on this situation, I know my learned friend wasn't in the Court of Appeal, but if we look at the order of Lord Justice Dingman, this is at in the supplemental bundle, page 38 on the actual PDF, paragraph 8. You can see the court, because the court, in colloquial terms, gave us all quite a hard time at that hearing as to where it was all going. I understand, the concerns. I think we all had them. But you can see that at the directions hearing, in front of Lord Justice Phillips, both parties agreed that the issue of whether the appellant may still be removed under the Dublin 3 regulation irrespective of age, so that's the time point, or whether the time limits have expired, must be resolved. The parties also agreed that the least worst way for that to take place was for permission to amend the grounds to bring in this new point, and then so on and so forth. So to paint a picture, as the Secretary of State sort of, reluctantly dragging the appellant through all this, it is not fair, because the Secretary of State's only other option was to concede a point on age which wasn't accepted, because the expert advice from those at the time, those contemporaneous assessors, was against that, and to concede a point of wider application, which wasn't accepted either, and was robustly defended. That's the difficulty. I mean, should the Secretary of State just concede all these matters to save costs? But it doesn't save costs, because in fact you then have to pay all the costs of what's gone before, unless there's an offer not to do that. And there was no hint of any such sort of situation here reflecting the block hands. And I do submit that it penalises the Secretary of State in costs, because what's happening here is not only is the Secretary of State not getting her costs paid, she is paying the costs of somebody else. And that's how I use penalisation. And it is on the basis of poor conduct of the litigation, so on the follow-up ground, as it were. So it is a fair characterisation of the position. If costs were just falling where they lay, publicly funded on both sides, then that's a different situation, isn't it? But what's happening here is a positive order to pay costs. And in my submission, that leaves a good sound reason for doing so. It's clear, because otherwise it just gets extrapolated.
And you say that even the costs reserved back in 2018, you shouldn't have to pay those.
Well, I'm wondering whether they are actually caught by other orders, actually, and I'm wondering whether there are. We haven't received the cost bills, so we don't know if they are being demarcated out anyway. In terms, so we don't really know what costs we're talking about there and how significant they are.
I'm being much slower than my lady. I'm not sure which order is said might deal with them.
I think it's Master Meacher.
Yeah.
So Meacher, on page 40 of the supplemental bundle,
Yes.
deals with all the costs of false imprisonment. So anything
Yes.
that's false imprisonment has been dealt with or has been recovered
Why
already.
does that cover the?
Which would be some, I suppose, some of the JR costs could well be in that.
Well, we
and that
haven't
would-
received bills.
But we don't know. But I'm just trying to work out the
Exactly,
lines.
so there
And
is
then the
one-
other positive costs order is the Dingerman's costs order, page 36, which is the costs of the Coca, not Croker. Coca.
That's all post the February.
So
18
there's sort
orders.
of discrete parcels.
Yeah.
So we've got a sort of up to a point, which may or may not include all the JR costs in the sense that because the unlawful detention claim was brought within the JR, we haven't seen how it's demarcated, if indeed it is, that time was allocated and they say, well, actually, I'm going to use a proportionate approach.
But it's certainly the case not all the reserve costs have been dealt with. For instance, the cost of issuing the claim.
As I say, it depends on the detail, I'm afraid, my lord. If my learned friends are going to, well, it wouldn't be my learned friends, but if the cost assessment people say it's too proportionately difficult or whatever, we can't separate out the unlawful detention costs from this from anything else, because it's not like, in private law we might have different heads of claim. If you see something where you might see costs quite clearly being attributed when they're billed to, but unless you take a proportionate approach, I think it's very unlikely that someone's going to say at the time of recording the costs, well, I think I spent about 20 minutes on the unlawful detention and 40 minutes on
No, that's an issue we're familiar with.
But also, either you or Miss Broadfoot made the submission that age was relevant to quantum on the false imprisonment claim. So, for all one knows, the negotiated settlement of £23,000 could have taken into account the risk on the possible parameters of an outcome on age. I just don't know. But was it you, your submission, or was it Miss Broadfoot's?
I think it was my submission.
That age was relevant to
Yeah, that-
quantum, because clearly if you falsely imprison a child,
Yeah.
that's more serious than falsely
That's right, and
imprisoning an adult.
by the time of the Dingerman's, Lord Justice Dingerman's order, the position had moved on because the Secretary of State was accepting that even as an adult he was entitled to substantial damages.
Understand,
So the distinction between the two was less significant.
I understand, but still, in answer to, I think, to the debate we're having, is that there is not a clear, bright line between the false imprisonment claim and the question of age.
So, in answer to my Lord's
Yeah.
question, I think it's a bit sort of watch the space yet to be determined, but it's certainly possible that there are costs previously that have been reserved.
Well, why is it
fall into
watch
it.
this space to be determined? Because it must be before us at the moment. But the order.
Sorry, I just mean in really practical nuts and bolts terms,
Yes.
in terms of how the costs are actually being billed. And if we'd received a bill of costs for the unlawful detention, so we could go down and we could say, actually, look, the total costs here were 20,000. We can see that 15,000 have been allocated to unlawful detention, 5,000 to certification, and therefore, that's not the situation that we're in. So.
So can I just say that I'm instructed, and I don't know if it's helpful, that normally in these sorts of situations where you have a partly unlawful detention, partly something else, the unlawful detention case costs generally form half of the issuing costs. That's normally how it works, unless it can be very specifically allocated. Don't know if that's helpful.
But that exercise hasn't been done, as I understand it. So,
But we
is that
would
right?
be very grateful to note that,
Okay.
and that will certainly be something that might speed things up if it ever comes up. So,
But am I right, Miss Anderson, to both of you, to have in mind that you've got this reserved costs order, which doesn't really amount to very much in 2018. We just know somebody made that order, but it doesn't say where they're going to end up. It just reserves it. But there are these two positive costs orders that we get in 2020. So we do know where those costs fall, but we don't know which lines of expenditure come within those. That we don't know, but we do. So we're looking at everything that isn't the appeal, the COCA appeal, and unlawful detention. That's what we're looking at here.
I think it's fair to say that the preponderance of the cost would still be the October hearing, which of course everyone expected to be determined by
Of
the
course, yeah.
tribunal itself. Because we know that sort of there's a sort of line drawn. There's some that drop out, which are covered by the Lord Justice Dingman's order. So we know that from a certain date to a certain date, there can only be those costs, and those definitely have been awarded to the claimant side by agreement. That sort of falls out of account. So what we know after that is everything from then onwards, which is just preparation for that October hearing, because age assessment was shelved by then, because it was a preliminary issue. So we know that from the end of the Lord Justice Dingman's order up to the October hearing, those were the costs that were principally in concern. There might be some costs previously subject to how they fall in terms of allocation of what's being claimed. But I understand from my learned friend only 50% of the JR costs, so we might say that 50% of the costs from the JR that haven't
Flushed out in some other way.
The thing we have to bear in mind at all times is that these are matters of principle for you and general application. There are matters of hands in the pocket of the claimant. So we can't be cavalier about it.
Absolutely, my lord. But anyway, even if it comes in the pocket, I would be the very last person to be cavalier about it. I find the cost astonishing. If anyone has ever tried to raise money for charity, and then we look at the legal costs that we deal with every day as if it's nothing. I mean, if I've come across cavalier in any way, I've certainly.
So I certainly wasn't suggesting that you were. I'm just saying that this is a situation where a claimant at the start of these proceedings, a decision was made against him on the basis of a non-compliant age assessment, and that's accepted. And one has to look at the question of the extent to which, in having established that, and it never having been established the contrary, he should effectively be deprived of some of the damages he's been awarded by way of clawback of costs, and that's the reality of it.
But my lord, I hope I've answered that in that he had the option at that time, if that was the real position, to not challenge the next age assessment. Right? If his only point was, this is not Merton compliant, as it were, that technical point, and that's why you've made your decision, then he could have stopped then and there would have been no more costs. But he has actually continued to challenge the subsequent age assessment, as it were, and continued. So it's not right to say that this is, from the beginning, decided. Because, as I say, if
But the age assessment was going to be done by the Upper Tribunal. and it was never.
No, there's then subsequent. What happens is there's a non-compliant age assessment at the beginning,
Yes.
right? There are then subsequent age assessments by other local authorities,
Yes.
as it were,
Yes.
which, so the advice the Secretary of State's continually getting is this individual is an adult.
Yes.
And those are also now being said to be wrong, and the individual has time, as well. Lady Justice Whipple, my lady, indicated. The claimant himself is saying, "Give me more time because I want to get in my, sort of own age assessor and so on and so forth, and argue this out, properly argue out whether or not I was a minor at the beginning, because that is the important point."
Yeah.
And that's what's being said, even at the Court of Appeal level in front of Lord Justice Dingman's. Everyone's had item. This is the important point. So if what their case really was actually this has all been decided previously, and there's nothing to decide here, effectively the Secretary of State's just sort of stringing this along to take advantage of delay or some.
No,
then
that's not their point. Their point, forgive me, I think their point is that yes, we wanted to have it determined that we were a minor, but that's no longer but that's gone by the board, and that's because of the EU exit. So the point is that has never been finally determined.
He wanted it determined not just because of the EU exit, though.
No.
But sorry, my lord, I understand the point, though. I do understand the point. So, in my submission, all I'm really making is a very simple submission. Is it's just unfair to cast this as the Secretary of State unreasonably digging in heels and trying to hang on to a second bite of the cherry or something of that nature. That is not a correct characterisation of the position. The position is there's a claim to be a minor. That's a live claim for various different reasons. Everyone accepts it's a live claim, and that's what the courts are setting about determining, as it were. And it has never been determined in his favour, and it's not good enough in my submission to sort of say, there's a default position where the Secretary of State, for defending a decision, ends up paying the costs because the Secretary of State has defended the decision and not settled. Where the Secretary of State, in good faith, considers that the decision is a reasonable one, it's almost like sort of penalising the Secretary of State for being the decision maker, as it were, because it isn't, as my lord indicated, that unfortunately a lot of these points are points of principle and are ones that have to be applied consistently across the board. And so, even though it would be really convenient not to have to uphold the law, it would be extremely convenient and much cheaper for the Secretary of State just to say pragmatically, well, this one looks a bit difficult, or we might not be able to do it, and just sort of not defend claims. It's the normal thing. We'll have to consider the legal merits of the claim, and that's the basis on which advice is mainly given. Of course, you look at pragmatic matters as well, and the wider scheme of things, but if you concede one case, you have to have a principled basis for doing it, because the next one will be asking for the same treatment, and that's not a sort of floodgates point, that's a genuine point about arbitrary behaviour by public authorities, that you can't just sort of say, oh, this looks too hard or too costly, or it's not the same as being a private litigant, where you can say that, you can say, and as I say, if there was ever at any stage a sort of offer to say, let's draw a line, that would be a different situation, but you can see at the Court of Appeal stage, the court records, after a hearing, that both parties are saying this needs to be determined. And it's the respondent's point that needs to be determined. But putting it into the legal framework, as I understand it, my learned friend's answer, insofar as it is, to the MH Eritrea point, is to say that, well, it's all very nuanced and very factual. And in my submission, that's just not a good enough answer to the fact that there's very clearly a need for a causal connection between this case. And there isn't one here, and that's why all these other things are being pointed out. You simply wouldn't be being taken to the things that are really implicit criticism of the judge, and so on and so forth below, all these rather difficult points, if there was a very clear causal connection on the merits of the individual claim. So, ground one of my submission is made out, and there isn't a response to that that shows that there isn't an error, material error at law in the decision of the Upper Tribunal judge, because he gave his reasons for it, and my submission, those reasons show an error of law, misunderstanding of things. he didn't make a sort of nuanced factual decision or whatever's now being alleged. And so, prima facie, his decision should be set aside. The question is then what the court does about it next.
Well, it's noticeable that Ms. Broadfoot didn't actually take us to what the tribunal judge said.
I think I showed you it in opening.
You did. I'm saying
Oh,
your opponent
yes.
did not.
Yes.
She did not seek to show us on the written page his nuanced approach.
No, I think she just sort of said it's broad enough. Being successful is broad enough to encompass all these things.
Yes.
But the judge was quite clear at why he thought it was a success, and in my submission that was not a legally sound approach on the authorities. So when it comes to the sort of fallback position, in my submission, it's I'm afraid just not good enough to say we would have won below, and here's my skeleton argument. If this court's going to be asked to decide what's really quite a difficult point of EU law, that's certainly not pre-decided in the other Eritrea case, WK Eritrea. If it was that straightforward, I'm sure the tribunal would have done it. But it's not predetermined. That's why there was something to argue about. And in my submission, that certainly wasn't the decision of the tribunal that heard those submissions, that this is really tolerably clear or straightforward or however it's put. So that point has to be developed in this court. It hasn't been developed in this court, and in my submission that is because, one, the court shouldn't be doing it on the case law because it's only rarely that this court would be engaging in this underlying dispute. It would be necessary for you really effectively to decide it, because it's not the kind of point that's sort of tolerably clear on a broad analysis, as it were. It's a point of interpretation of EU law. So I'm afraid it's not one without developing those points and explaining to the court why it would have gone that way. This court can really act on. And then in my submission, the other sort of basis is this conduct basis. So it's not the merits anymore. This is the conduct of the litigation. But in my submission, firstly, the judge below rejected that, and so you do have a first instance judge close to the situation, or closer, who's heard these arguments and says no, that the time it took was inherent in the proceedings. That's the finding of the judge below. That he doesn't attribute any blame to the Secretary of State for the conduct. And one has to bear in mind that this is not a sort of straightforward cost for conduct equation here. What's really being argued is it's a delay off the cliff edge argument. Is that sort of, which, so you're not just saying you behaved badly. That's why my learned friend struggled a bit with the terminology. So you're not saying this is obviously bad behaviour, because it would be quite hard to frame it in those terms, wouldn't it? That the Secretary of State has behaved wrongly to be such as to be penalised in cost by not dissuading a judge from taking a course of action that the judge has decided to take initially of their own motion. I mean, you can see how difficult that argument is. And that really is the high point of my learned friend's case.
Do we have any material as to the exchange between the judge? There's no transcript or anything like that.
I don't. It wouldn't be for me to put it in because I'm not relying on it.
No, I understand.
And my understanding is there isn't one before the court, but insofar as it was put below, it was absolutely rejected by the judge. The judge made a positive finding that what's being argued is not right. That these were sort of normal and or may not be normal, but not unexpected inherent delays that have occurred because of the and that is the problem with the cliff edge argument, because why do you only look at that bit of the time period? Surely the court would have to look at every bit of the proceedings to sort of check everybody who's done everything quickly. So is it justified that the claimants took time to instruct an expert on that, or to do that, or was it due to the pandemic, or was it due to court delays, or was it due to, because what you're effectively doing is penalising the party in costs for the time taken on proceedings. That is the actual underlying argument here. And in my submission, there just isn't the type of conduct that ought to be penalised. Because as I say, for every delay by the Secretary of State, there might well be another delay. and it's not being put before the court in that way. My learned friend hasn't dealt with the chronology as a whole. It's really just highlighting on that particular episode in which the Secretary of State has already paid the cost.
But conduct isn't necessarily the same thing as delay, is it?
Well,
And isn't the, just to put to you what I think may be being said, I'm not sure if it is. The point here is that this whole process came to a shuddering halt on EU exit. And that meant that not only that the proceedings did not proceed to a conclusion, but that a lot of costs had been wasted. And certainly the costs of the hearing in October were wasted because there was never a judgment. And I think the argument to some extent is that those costs are wasted in a sense due to the conduct of the Secretary of State.
Well, my short response to that, my lord, is that if it could have been anticipated, which is really what's being argued, then it ought to have been anticipated. But everybody proceeded, as you can see from the Lord Justice Dingman's order on that this ought to be decided, this point was being raised by the court. And that's why the tribunal heard it. And it might have been decided, as it were. We simply do not know. And perhaps that's why the tribunal is very careful to say that the delays were inherent in this case. Because really the main reason it wasn't decided was because there wasn't a judgment, but not in circumstances where it was inevitable there wouldn't be a judgment. In circumstances where it was actually, in many ways, a bit of a surprise on the judgment. Now, we don't know what went on in between. I mean, there may be lots of things that we just don't know. But it certainly wasn't anything the Secretary of State did between October and the end of December that meant there couldn't be a judgment, if you see what I mean. That's just a situation that's happened.
But for example, it plainly would not have made any sense at all to have embarked on the preliminary issue on, say, 18th of December.
Absolutely, my lord. That tends to suggest that everybody anticipated there would be a judgment. And there was a wider benefit to it. It wasn't just, in all fairness to my learned friends, it wasn't just for this case, as it were. It was an issue of sort of wider sort of relevance.
Well, I'm not sure.
My lord, I can't, all I can say is that it's one of those cleft stick situations where when it comes to cost, if the Secretary of State had conceded this at any point, the Secretary of State would have had to pay the cost, because that would have been the situation. So there was no point at which there was a sort of no costs option, as it were. And the Secretary of State firmly and in good faith believed in the arguments that were being put forward. They were heard by the tribunal. The tribunal gave no indication that it thought this was a straightforward matter, where the Secretary of State was taking bad points or anything of that nature. And it just shows the different impressions that people get when they walk away from the judgment. But I'd say that we're, on the, it doesn't matter, it's an irrelevant matter. But on the appellant side, we were quietly confident that we thought it would go our way. But
I'm not sure you should be saying that.
Absolutely, but my learned friends are saying that it's very clearly would have gone their way, my lord, and that's the only reason.
Yes, but I think what counsel's impression is.
That's what I'm saying is irrelevant, and so that makes my point that this court can't proceed on that basis, can it? It can't be that the respondent comes here and says I would have won, because it's just that absence of any objective foundation for that. And that's relevant to tolerably clear.
Well, the person to have given the indication would have been Upper Tribunal Judge O'Callaghan.
Yes. And all he did was refer to it as a complex point of law, so tending to suggest it was a difficult point. And he certainly didn't proceed on the basis of that it was tolerably clear or anything of that nature. And that's enough, as you indicate, for it to be said in this court that this court can't proceed on any other basis in my submission. So on the fallback position, which is, even if there isn't success, it's tolerably clear there would have been success. You have my submissions on that, and then you've got my submissions on the sort of final fallback thing, that there was any conduct in these proceedings of the proceedings, and that must be the point, that is sufficient to base an adverse cost order for all the costs against the Secretary of State, because the particular part that's being argued about and highlighted, the costs have been awarded to the respondents for that bit. So what you're actually doing is extrapolating from that to delay. Because I mean, that's why I know it's a tortuous submission, but that's why, in a sense, it's delay that's relevant to costs, because it's pushing them over the cliff edge with the argument. So, in my submission, wrapping it all up, the reasons the judge gave of you've conducted your litigation reasonably, and by dint of a fluxion of time, you've sort of achieved the ultimate effect of what you wanted, is not a sound basis for a judgment. If the age assessment obviously had been determined against the Secretary of State or local authorities, or there was some indication that would have been the situation, then you would have been into a different situation. But in this one, no order of cost is the appropriate order. Unless I can assist further, there's no.
I have a question, but it's very
Yes. Please may I check, Ms Anderson, what was said by Ms Broadfoot? It's on the point about unlawful detention damages, and she said that they weren't Hamati unlawful detention damages, and they must have been consequent on something else. And you're absolutely right that Hamati, I think, is, I've just looked it up, it's November 2019, and the consent order I'm looking at, page 13 and 14 of the supplemental bundle, is dated February 2018. So what was the basis of the concession of unlawful detention?
Well, I think is it that the Hamati judgment in the Supreme Court?
Yeah, I think it had been in the
Might have been in the Court of
instance,
Appeal already,
Court of
but
Appeal.
the Supreme Court handed down judgment on the 27th of November 2019.
I've definitely seen a 2019 report somewhere this morning.
27th, I've got it in front of me.
Yeah.
It was reported in 2021 actually, but and so I just wonder, and so Ms Broadfoot says that the basis of the unlawful detention damages wasn't Hamati, unless perhaps you were looking at an
And I
earlier
think
stage.
it might be, but actually I think this might go back to my, I'm speculating now, and I want to really take instructions on that. But,
Could I just have something on that? I mean, I suppose I just would like to know what was the basis, because for the Secretary of State to concede damages for unlawful detention, I think I would want to know what was the basis of that concession.
Yes, I think I'll have to take specific instructions on that, because I don't want to sort of say something off the top of my head that's
Thank you very much.
accurate.
Yes, well, can you let us have something in writing, short?
Oh, absolutely, Mo. And there won't be any submission. So, I mean, it will be literally
Yes.
a sort of...
Thank you, an email, yeah.
And I've just got a point of information, which I think is completely irrelevant, but if I can ask it, well, maybe more from Ms Broadfoot, simply how the statutory charge works. Does the legal aid statutory charge, obviously the respondent solicitors are paid by the legal aid agency, and then it's the legal aid agency to come, if it wishes, against the respondent. Does the legal aid statutory charge bite on the damages recovered by the respondent in this case?
Can you allow me to turn my back to
Yes,
those
thank
who know
you.
better than...
Thank you.
My lady, would it be acceptable if my junior actually answers that question,
Yes.
because he's much more
Sorry.
steeped in
As I say, I
statutory charge
suspect
than
it's
me?
completely irrelevant, but I might as well ask
um,
it now. We have a few minutes in hand.
If
quickly.
that's,
Yes,
that's
thank
all right.
you.
Thank you.
I'm grateful, my lady. Yes, so in this case, the costs that were incurred by the respondent in the course of these proceedings that were not covered by, not recovered from the other side, would be paid by the legal aid agency. And then the legal aid agency would then make a claim against his
Yes.
damages, which would wipe out his damages.
Yes, sorry, that's what I said.
Exactly.
But the statutory, so there are exemptions and exceptions, including exceptional hardship and so on and so forth, aren't there? It's a complicated regime. I understand the mechanism, but has any attempt been made so far to enforce by the legal aid agency to enforce against the damages?
Well, he's been completely successful so far.
Yes, but he's had no order for costs. Oh, no, he's been completely successful, so he's got an order for costs against him.
Yes.
Yes.
Understood.
That's just been-
Yes, and for irrecoverable costs, what happens to those on assessment if you don't get every penny? the legal aid agency just suck it up? Yes.
Yes.
Yes. All right. Thank you. All right. Yes. Thank you very much indeed.
May I just comment? I know my lady's got the point, but of course there's statutory, there's jurisprudence that says the means of funding is irrelevant.
Completely, absolutely, completely understood.
There
There was something said in.
behind me would probably want me to just point out that the jurisprudence is very clear on that.
Absolutely, no, it was raised during the course of debate, and I just wanted to get my facts clear. Thank you.
Yes. I think I just should say, I think Ms Anderson reserved addressing your respondent's notice, Waterford.
Oh, yes.
So I don't know whether or not I don't think there was very much anything new, but I don't know if you anything you wanted to say in relation to what she said in answer to your respondent's notice.
No, I think I've said it all, but I've also set it all out in our skeleton argument.
Yes.
So thank you.
Thank you very much. Well, thank you to both sets of advocates, both those on their feet and behind them. Thank you for your very helpful submissions. We'll reserve our judgments in the usual way, and you'll be notified of the date when they'll be handed down remotely. Please would you'll receive them in draft in advance, those whose details have been provided, and please, that's for the purpose of providing us with corrections or other obvious errors, not for re-arguing the case, as you know. And you'll be very aware now that the strictures regarding the confidentiality of those drafts and the consequences if those strictures aren't obeyed. If you once you've had the draft, if you can agree an order, we'd be grateful. If there's anything you can't agree, please let us have written submissions on those points, and the timetable for that will be set out in the email accompanying the draft. Otherwise, that concludes the appeal. Oh yes, when will you let us have your
Your line of
your
assistance. Not pressing for it, really, just to know.
Can I say Friday, just to make sure that I've got a chance to get it all approved?
Yes. Thank you very much.